9 p.m. You're with India Development Debate. I'm Sandeep Gurumurthy, and joining me in Delhi is my colleague Supriya Srinath. Tonight, it's curtains for the ugly slugfest within the judiciary over the medical college bribery case. A three-judge Supreme Court bench today struck down a petition seeking a probe by the Special Investigation Team into bribery charges against its own judges, even as it came down heavily against what it called forum shopping by a group of petitioners. The ruling comes as a big relief and puts an end to the slugfest among the jurists over clash of interest charges and judicial hierarchy. Joining us on the show this evening, it's a stellar panel on the India Development Debate. Soli Sorabji, former Attorney General of India, Justice Mrs. Gyan Sudha Mishra, former Judge Supreme Court, Justice M.F. Saldana, retired Judge Bombay and Karnataka High Court, Aman Lekhi, Senior Advocate Supreme Court, and Kamini Jaiswal, Senior Lawyer and one of the petitioners in this case. Thank you all so much for taking time and joining us on the India Development Debate. Mr. Sorabji, I'm going to start off with you, and we don't want to beat around the bush here, but has this entire episode hurt the institutional credibility of the judiciary?
I agree. Supreme Court has been the casualty of all the developments. It could have been really done in a different manner. Conceding that Justice Chandrashwar shouldn't have really himself said that the bench should be constituted. Maybe he was wrong, but the Chief Justice also overreacted, and he set aside the order without the matter being listed before him and without anyone appearing before him in support of Chandrashwar's order. So this thing is not good. What I fear, what I really am upset about is that the common man, the consumer of justice, the common consumer of justice, his faith in the independence and neutrality of the Supreme Court is affected. And that's something which I find very disturbing. That should not have happened, but unfortunately it has, and I'm sure it can be done properly. I'm glad the three-judge bench who heard the matter and delivered the judgment today refused to pass any contempt, refused to initiate any contempt proceedings against Prashant Bhushan or Kamini Jaiswal, because after all they did what they thought was the right thing to do. They didn't have any axe to grind. But the whole thing has left a very taste in the mouth, bad taste in the mouth, and I'm very, very upset about the developments.
Right. Right. I'm glad you're being candid there, and I'm glad you're putting it out for viewers that you are upset with what has happened today, and it does leave a very bitter taste. But Justice Saldana, if I may bring this to you, there is one thing about crisis of institutional credibility, and has the judiciary done itself harm? But I'm going to make an emotive appeal, an emotive question really here. If you look at the common man in this country, we turn to law, we turn to the judiciary to safeguard us, sometimes against legislative or executive overreach, or sometimes against corporates as well. But this is a case where the judiciary seems to have really crumbled its own credibility. Will you agree with that assessment, or do you believe this is a bigger issue than one is making it out to be? You've had one of the most prominent people in one of the legal luminaries, Soli Sorabji, say that this leaves a very bitter taste. What's your own verdict on this? Has the judiciary harmed itself in this entire episode?
I think the judiciary has done immense damage to itself. Speaking for myself, and I think I represent the views of probably millions of Indians, there has been a serious credibility crisis. And this was one opportunity. I don't see anything wrong when somebody comes to the Supreme Court, the highest court in the country, and requests for an independent investigation. I do not think the CBI or the police or any other authority is really competent to go into a matter like this. And let us look at it this way, that the bench of the Supreme Court, which originally heard the matter, let's not go into procedural niceties, who should do it, who should not do it, that is incidental. My point is only this, madam, that the issue is so very important. It's almost the survival of the system now that we are concerned with. And Mr. Sorabji is right. I mean, I can only support him by saying that, I mean, he says he was hurt. I have been devastated. I've spent 35 years as a lawyer, 16 years as a judge. And even today, I'm working day and night to improve the credibility, the efficiency, the professionalism of the system. And when somebody comes and says that there are some blemishes or there are allegations, I think they should have been inquired into. An SIT should have been set up, and if required, even with folded hands, may I request the court to review this decision. It can be done. It should be done, it can be done, and irrespective of whether the petitioners ask for it or not, I think the court itself should review the decision, refer it to a larger bench, and go into all the different aspects.
Right.
For instance, one of the issues that has been debated for long.
Right.
Yes.
Justice
is
Saldanha,
the question as to whether judges at any level are accountable or not.
Fair enough.
Yes.
Justice Saldanha, if I get a word from Justice Mishra as well, who joins in on the show this evening. Justice Mishra, would you agree with this anguish that we are hearing from both Justice Saldanha and from Mr. Sori Sorabji? And do you believe that in the larger interest of transparency, here was an opportunity for the judiciary to take the high moral ground, to agree to setting up a special investigating team? Justice Saldanha says, what was the big harm in setting up an SIT to look into these charges of judicial corruption? Do you believe there was merit in that?
If I remember correctly, long back when during the tenure of Chief Justice J.S. Verma, there was an in-house procedure for going into the allegations against the judges, and primarily at that time it was against the High Court judges. But if at all there is a perception, I would say, because it's very it would be very irresponsible and reckless to say that merely because somebody has leveled an allegation, that should be straight away be given to for a probe by the SIT, because there has to be, even for a common man, there has to be a prima facie case for going into an investigation. So if at all there is a cause, then there was an in-house procedure at the relevant time by the judges to go into the allegations leveled. So I think judges can go into that and find out whether it is at all a case for investigation, because if at the slightest pretext some matter is given to the SIT for investigation merely because somebody has a perception about the credibility, I think it will be a greater damage to the institution, and the responsibility lies on the judicial fraternity and the legal fraternity to not only to see that justice is not merely done but seem to have been done, but it is equally the responsibility that it should protect the institution from reckless allegations and onslaught merely on the basis of a perception of someone. That I guess this. It is for the judges, maybe the judges themselves, why this in-house procedure is not resorted to. That may be a reason to deliberate and think whether that is at all called for. I personally feel that straight away, giving to the SIT for probe, that would be a very dangerous proposition.
Okay, dangerous proposition at the slightest instigation. But Kamini Jaiswal, I want to put forward a question completely bluntly to you. This speculative naming, and quote unquote that, as being talked about by Pratap Bhai Mehta, and he says it can actually put an instrument for seeking recusal and undermines the independence of judiciary. Now, the charges that were raised by the two petitions that went, to be fair, A, obviously did not name the judge where aspersions were being cast. The FIR also did not name him. And so in some sense, the naming and shaming was very speculative. And where does that leave the judiciary eventually?
I'm sorry, no judges were named, and it was not somebody's ipsedixie and apprehension and allegation. This was the case of one FIR that was registered. The FIR named 5 people specifically. CBI was investigating into the matter. There were people who were arrested, and in that there was something which could lead to the door of the apex court. All that was asked for in this petition is, please don't let CBI do it. Let a special investigation team supervised by a retired Chief Justice of India do it, because it leads to the doors of the apex court. We do not want the independence of the judiciary to be compromised, because we all know CBI is not an independent investigating agency, and CBI is totally under the control of the government, and that itself would compromise the independence of the judiciary, and that was the only reason why a special investigation team was asked for. It's not as somebody just made allegations and investigation. There is an ongoing investigation. We were only asking for transfer of that ongoing investigation to be given to the SIT. No allegations were made against anybody specifically.
Aman Lekhi, comment on that. How do you read this point? Do you agree with Justice Mishra's view that by forming an SIT for a case like this, you're potentially damaging the credibility and the independence of the judiciary? Or do you agree with the view of Kamini Jaiswal saying that, while no allegations were being made, some of the, as per the investigation done by the CBI, it sort of leads up to the door of the Supreme Court, and given the obvious conflict of interest, it's probably only fine that a special investigation team looks at it in the interest of, the faith of the public in the judiciary, because this involves a case of judicial corruption. Aman Lekhi.
I personally find it a bizarre state of affairs. I just heard Kamini, and I've heard the petition which Prashant Bhushan filed. The purpose of the SIT was to insulate the judiciary from executive interference and therefore protect its independence. But the manner in which the whole case has been handled, the attention is no longer focused on the executive, which is now irrelevant, and the entire attention is focused on the judiciary. And thanks to the manner in which the matter has been presented, which in my opinion is seriously wrong, this issue of institutional crisis is now to the fore. So no one is now talking about the executive. SIT is now irrelevant. And in focus is the Supreme Court and the lack of credibility of the judges in the Supreme Court, the doing of which lies squarely at the door of the handling of the lawyers dealing with this particular case. While what Justice Mishra said could have been done differently, as Mr. Sarabji pointed out, but what is more pertinent is, why did what Justice Mishra did actually happen? And you can't, in this case, ignore the role of the lawyers, because you can't file 2 petitions simultaneously, have them listed before 2 different benches, and hope that the bench of convenience or choice hear that particular matter, because that is doing violence to the way in which matters are held, and that will in any case divide the Supreme Court into a number of judges, and it will not have any consolidated entity as such. As far as the holding of the SIT is concerned, I think this particular prayer itself flies in the face of Veeraswamy's judgment, because this is precisely the plea which was raised, that there should be no external check on the prosecution by judges, because in that particular case the issue was that the judges can be prosecuted in the Prevention of Corruption Act. And while Justice Verma had dissented and had pointed out that this would actually make the judges vulnerable, the majority of the Supreme Court said that insofar as the judges are concerned, where allegations are being made, there is absolutely no legal objection to their being probed by the police. Now, the CBI is also a police agency as such, and much as in the same manner, the CBI, as Kamini Jaiswal says, claims to be under the influence of the executive, and as far as the police is concerned, which is the Home Ministry in the state, in any case, it can some way control it. Notwithstanding that, the Supreme Court had held, and that judicial precedent to that account, that there is no bar on judges being probed, only safeguard being that before an FIR is registered, the Chief Justice's opinion, of the Chief Justice himself is involved, some other judge's opinion is taken. So in my particular opinion, if objection was to a particular judge, then there was precedent that the objection should have been taken before the judge concerned, not before a different judge, as is done in the instant case. And there had to be good cause stated in application on affidavit, setting out grounds why they believe that the recusal should take place.
Okay, Aman Lekhi, you made your point there, and you're essentially referring to one of the observations which was made by the Honorable Supreme Court that did say, that did refer to forum shopping. Mr. Sorabji, is there merit in the allegations of forum shopping that the court did observe today?
I don't know, really. I don't want to say anything about it because but I can't understand why was the same petition filed again by Kamini Jaiswal. That gives the impression of forum shopping. After all, it was pending before another bench. Then you again get it listed before another bench. That seems to give the impression. And look, what would happen is, every time you don't want a judge on the bench about whom you think he will pass an unfavorable order, you make allegations and ask him to recuse himself. And that's absurd. Then there will be no end to it. This must be done in a spirit, both the bar and the bench, the legal fraternity, the judicial fraternity, have to really act together. After all, what's the aim? Aim is to see that independent justice is meted out. And for that, both the bar and the bench have to work in a cooperative manner, not in a confrontational manner. And
Yes,
that's not happened in this case, and I'm very unhappy about it.
Sure. Kamini Jaiswal, it's a direct question from Soli Sorabji. What was the need to have filed another petition? Because that obviously raises aspersions of the fact that this is nothing but forum shopping. Kamini Jaiswal.
Listen, forum means going to another forum. For me, the Supreme Court is the Supreme Court. The first matter also was listed mentioned before Justice Chalmeshwar because the Chief Justice happened to be sitting in the Constitution bench, and for years this has been the practice that when Chief Justice is sitting in the Constitution bench, the next senior most judge hears the petition. The first petition is different from the second petition. We kind of improved on the second petition, and we did want the matter to be heard immediately. When we mentioned the second petition, the first petition had not been listed before any bench. Bench had not been assigned. When the matter was mentioned on Wednesday, the learned judge, again it was Justice Chalmeshwar who heard the matter, and he said, listed before me on Friday, because he was at that time the senior most judge. That since the matter was not listed before him on Friday, and we were told that the bench was, it was being listed anywhere else. We were not told where it was being listed. And we were thinking that there was urgency in the matter and we required immediate orders, because as soon as the government gets to know or the CBI gets to know that there is a matter pending like this, they might tamper with the evidence. So our immediate concern was sealing that whatever evidence has been received and whatever documents are available, and that is exactly what the prayer we made on Thursday morning before Justice Chalmeshwar. And how do we reconcile to this? That two judges of the Supreme Court feel it's such a serious matter that 5 senior most judges must hear it, and 3 judges of the Supreme Court dismiss the same petition.
Okay. I'm going to take away this debate from charges of forum shopping and actually get this back on track as far as the relationship within the judiciary is concerned. And Justice Saldana, if I may pose this question to you, do these events and the lead up to these events also demonstrate that the judges don't trust each other to safeguard the institution of judiciary? There is a very fractious relationship even within the courts. There seems to be divisions and fractions within the Supreme Court itself. Do these events demonstrate this?
Madam, I have spent 16 years in the judiciary, in the higher judiciary, both in the Bombay High Court and the Karnataka High Court. I have also been in close touch with the working of the judiciary, the Supreme Court and the High Courts. And judges are human beings. They may have different views, they may have different opinions on all sorts of matters. But I am sorry, I do not share the view that there are any cracks or rifts or disputes or disagreements between the judges in the judiciary at any level. And even here, let's assume now, let's go on, very rightly you have said, let's not go into procedural niceties. I would have personally felt that it would have been far better if the Supreme Court said that we will not leave an issue of this importance. There is a retired Chief Justice or just a judge involved in this case, and there are serious allegations. I think it is better to clear the air, because if these allegations are wrong, if they are unfounded, the SIT would have immediately said so, and it would have been a far more credible forum than getting a report from the CBI or some set of police officers. So I still feel that the opportunity should not be lost, and that there are much wider issues, because for a long time the question has been asked as to who is going to judge the judges. I had raised that question once in one of the cases which I heard. This is one. This has got to be answered. More importantly, the question of judicial accountability. Now, these are all serious areas to which we need to find answers. And we've got, my humble opinion, and I'm sure the others, the right-thinking people in this country share it. India possesses one of the finest judiciaries in the world, whichever way you look at it.
Right.
And I don't share the view that there are any rifts or anything else. There may be differences of opinion now and then.
That's a fair point you made. But Justice Mishra, do you agree with Justice Saldanha on the fact that there are no rifts or opinion? Because many would argue that that what happened between Justice Chalameshwar and, of course, Justice Mishra is a case of where many would argue that in some ways the Chief Justice of India was institutionally humiliated by a fellow judge, and the manner in which this entire case went on. Many would argue that he was institutionally humiliated for whatever reason. What's your own view on the rift within judiciary? Because people would say that if judges can't trust themselves, how can people in turn trust the judiciary?
You see, I would very much agree with Justice Saldanha that in my experience too, in the High Court as Chief Justice, as also in the Supreme Court, I would not agree with the view that there has been cases of browbeating of one judge, against the other, because first of all, one must understand that by the very nature of this profession and the nature of discharge of duties, there are bound to be differences between one judge and the other judge, because the views, what to talk of the judiciary, even in our homes, even in our family lives, we have differences. A husband might not agree with the wife might not agree with the husband, the parents might not agree with the children. So especially the legal profession, it's a very a very basic structure is that there are bound to be different points of view. But if you perceive and treat it that if you disagree with a brother judge or a sister judge, that is browbeating and making the other person feel low about his or her view, I don't think that's a very healthy way of looking at it. Maybe as an outsider, why among the judges, even the lawyers, they appear against each other in a particular matter. They might disagree, and yet they may have the best of relations. I don't think merely because one brother judge disagrees with the another judge, which is not very that is how we get dissenting judgments also. But merely because if you dissent with your brother judge or your sister judge, that means you are cowing down, or you are letting the other person feel I don't think that's the correct way of looking at the things. And at least fortunately for myself, although I'm in the recent past, I think I'm one of the judges who have written the maximum number of dissenting judgments.
Right.
And but then your stand gets your point of view gets vindicated if it is referred to the larger bench.
Right.
So if it is referred to the larger bench, if there are differences, I don't think that one should feel very anguished about it.
Right.
So
Right, right. Fair point, Justice Mishra. We can, I mean, I'm sure our audience will figure out if that kind of open dissent and that kind of open disagreement is good and is perhaps healthy for the judiciary, especially the way it was done, the twists and the turns one did see. But Aman Lekhi, I'm going to pose this question to you, and I know you are a different view, but the original order of Justice Chalameshwar, it was, it was almost as if it was, one had to see justice being done than justice just being done. Seeing that the fact that the judiciary was being unbiased, the judiciary was putting this whole concept of Caesar's wife being above suspicion to practice, one had to see this being done. Will you not look at the original order of Justice Chalameshwar in that light?
Well, I feel the means are as important as the end, and more so when you've got an organized system of law. The manner of thinking is covenanted and controlled. So you cannot possibly concede to any judge, or for that matter any lawyer, the absolute freedom to do what he wishes simply because the person thinks that he is crusading for justice. Because one's perception of justice may not necessarily concur with another's opinion of it, and there may be a different opinion about what justice actually is. Now, issue here is whether the Chief Justice ought to have heard the matter or not, which is a legitimate, reasonable point to take. The point is, there is precedent to say that if there is objection to a judge, the application for recusal should be made to a judge concerned. And Justice Chalameshwar is a very able judge, would be aware of this particular issue, and more so while hearing a mentioning matter which is for urgent hearings, for urgent reliefs, etc., not for constituting of benches. It will not behove a judge listing a matter to constitute benches to hear a matter, because that is unprecedented. And it would have been more appropriate if the submission which was made by the lawyer was recorded in the order, but the matter was referred to the Chief Justice, because the previous order of Justice Chalameshwar had said that the matter be listed on Fridays subject to whatever order the Chief Justice had made. And a day later, there could have been no change in circumstance for Justice Chalameshwar to change that particular order and hear the same very matter that day itself. Appropriately, both matters should have been listed for the Chief Justice or an appropriate bench on Friday. And any objection which the parties may have had to a particular judge hearing the matter should have been made to the judge concerned. It is not as if the objection could not be taken, or this was the last only opportunity available for taking objection. If there is a measure and a method for taking action, I don't see why that should not be taken. And the reason why I insist it should be taken is because then situations unfold the way this has unfolded, because we get embroiled in technicalities and issues which are actually extraneous to the substance, the meat of the matter, and deal with the manner in which the matter is presented and not the substance that the matter has. So I personally feel it was inappropriate, and objection should have been taken in a manner which is stipulated, for which there is precedent before the judge concerned, for good cause. Not simply because there is an opinion that the judge may be involved, and the way in which we are proceeding, we can't trust the executive, we can't trust the police, we can't trust the judiciary, and only handpicked people of those who are petitioning the court should be trusted with judgment is something which will actually undermine the country as a whole, because who do we trust then? Okay. We can't trust the police, we cannot trust the CBI, we cannot trust the Chief Justice. We have to just trust someone who we feel is good enough to hear a matter, in whom we place and repose justice. This is not my perception of what is good or ideal for the country.
Okay, that's a very strong rebuttal coming there from Aman Lekhi. But Kamini Jaiswal, I have to give you a chance to counter that, and to the point that Aman Lekhi made, and to the larger point that was there no other way to secure the recusal of the Chief Justice of India without departing from existing court procedure, without sort of embarrassing the institution, without embarrassing the Chief Justice of India? Was there no other way to secure?
Who is teaching court procedure? Who is teaching me court procedure? What is this court procedure? I said that it is practice that when Chief Justice is sitting in a Supreme Court, mentioning is done before the next senior judge. This has been the practice for decades. In the first matter, Justice Chalameshwar directed the matter to be listed before him on Friday. In the next matter, he decided to take it up. Now, I don't understand what kind of practice I am being taught, and in any case, if the matter was listed before the Chief Justice, then the application for recusal would have been made. The matter was not listed before him. Even on Friday, it was not listed before him. It was only after suddenly at 2:45 we are told that the matter is listed before the Chief Justice at 3 o'clock. Then we went there and orally Prashant asked for the recusal. When do you make an application for recusal? Only if the matter was listed before him in advance. Matter was never listed before him till 2:45. At 3 o'clock we are told they are constituting a 7 judges bench. At 3 o'clock we go there, there is a 5 judges bench. How do you deal with the matter? I am told make an application for recusal before the judge. Today that application therefore was made before Justice Khanvilkar, which also they say is contemptuous. I mean, I don't understand this practice, teaching me practice. This is the procedure, this is the practice. Okay. We all know nobody has challenged the primacy of the Chief Justice to constitute benches.
Right. Okay. I think Aman Lekhi wants to come in there very quickly, Aman, because I do want to go to Soli Sarabji. You want to make a point there quickly? Aman?
No, insofar as I think Kamini missed the point altogether. I had taken multiple points as to what the mentioning court could do, and also the objection to Justice Mishra was taken for Justice Chelmesha, which in my opinion is completely untenable. And if that objection was taken for Justice Chelmesha, the appropriate thing would have been for the submission to be recorded in the order and for the matter to be placed before the Chief Justice, rather than the Constitution being decided on the first 5 judges to deal with that particular matter. It is that what I am talking, and insofar as this issue is concerned, that is the method is as
when
important
he said
as
first
the
5 judges, it included the Chief Justice.
The way in which the matter is handled, the method is completely wrong.
Okay. All right. Aman Lekhi and Kamini Jaiswal, just give me a minute here. I get your point, Aman, there, and I think Kamini Jaiswal also has a point. We are not going to let this debate be dominated by procedure, so let's keep the process and the procedures aside for a minute. But Soli Sarabji, if I may ask you this other question, the 5-judge bench that was, and this has been widely reported, so I'm essentially speaking from whatever I've read and heard from my court reporters, that the 5-judge bench that was constituted, aspersions have been cast that 3 judges from there had actually heard previous matters related to the medical college cases, and which is why the question of impropriety perhaps has been raised. How do you view the constitution of this bench, which had 3 judges who were a part of the bench that had heard previous medical college cases?
Well, these 3 judges were there. The Chief Justice didn't take any part in that. I don't know, I heard Kamini say some objection to Khanvilkar, which he rejected. Look, what I want to say is, forget the facts of this case. Please, I want to say, application for recusal must be made on substantial grounds, cogent grounds. Otherwise, you can just ask for recusal of any judge whom you think will pass an unfavorable order. That cannot be done. Difference of opinion among the judges, yes, but there's no distrust. Difference of opinion doesn't mean there's a distrust of each other. And as I said, this is a matter of great importance to the institution itself, and the legal fraternity, judicial fraternity must find a way out on an appropriate occasion, and that is what they owe to the country and to the institution.
Okay, let's now take this conversation forward and find out where does the onus of this so-called cleanup lie. Justice Saldanha, come in on that. Where does the onus of a judicial cleanup lie? This whole notion that the institution of judiciary can only be safeguarded by judges. Do you think the time has come to question that as someone who's been a part of the legal system for so many decades? What is the way forward? Where does the onus of this cleanup lie?
You see, a cleanup has to come from within the institution. And I know, I don't want to name the judge, but he had written several articles, one of the retired Supreme Court judges. He said that numerous complaints, not only with regard to integrity, but numerous complaints, there are serious complaints sometimes with regard to competency, etc. Now, all of these need to be looked into, and that a high-powered forum is very necessary, and it is better that a forum of that type be constituted. Now, because you see, the point he made was, which I thought was very relevant, and which I want to repeat here, is that at no time should the impression be created that we refuse to look into things because because the impression with the public get is that when you refuse to examine serious issues like this, are you covering up? Now this is something which I would never like. You see, such impression should never be created. And he had mentioned this in several of his articles and speeches, where he said that unfortunately, in various circles sometimes, when an issue should be examined, that was why I started by saying that this is an opportunity. Now it does not, you see, one doesn't have to go into the facts too deeply. An FIR has been registered. There is a senior judge involved. There are some allegations which are which as Kamini Jaiswal said, they are sort of imputations against judges holding highest offices. Now a matter like this, I think it should be, in fact, when I remember at the time of that very unfortunate Roost Resort case in Karnataka, one of the things which I had pointed out was that it is very necessary that the credibility of the institution and of the judges should be cleared through a probe, because otherwise these lurking suspicions remain, and then there are areas in which people say that, well, the judges say that they cannot be questioned. Now that borders on arbitrariness. So that's the reason why I still feel and I still believe that it is not too late to examine the issue involved. Now if there are problems with regard to the constitution of the bench, if somebody has heard or not heard, or somebody is objected to, the bench could be reconstituted. The Chief Justice will do that. There's no problem about that.
Okay. Justice Saldana, fair point, Justice Saldana. But Justice Mishra, if I may ask you, is there a seeming unwillingness to address the rot in the judicial system? Because there seems to be this resistance to address and to put the house in order. Where are the checks and balances, many people will ask?
Yes, I do agree that, there should be some mechanism to eradicate, even if it is a perception about a particular issue. But what should be the mechanism? One has to delve very cautiously into this arena because of the serious consequences. While we have to protect the independence of the judiciary, we also need to take care of what is being alleged. So I, for myself, feel that, that in-house procedure that was mooted out in the memorandum of procedure, kind of a restatement of values, if I remember, if that caption was restatement of values, where the judges had to follow certain norms, and if there was a reason to investigate a particular matter, then there would be an in-house procedure. An in-house procedure, so far as my memory goes, has been applied at least in case of the High Court judges. Maybe that can be applied to the Supreme Court as well, and maybe the reasons may be like if you are rejecting a particular request or asking to go into further inquiry, or who should be the inquiring authority and investigating authority, if the reasons could be disclosed, that reason may be made available under the RTI, or, I mean, these are all the random thoughts. I would not say what I'm saying is just, it needs deliberation and a very serious thought as to how to evolve a mechanism where we have to balance between the two extremes, where the faith of the people is not eroded, at the same time independence of the judiciary also is not sacrificed, that just at somebody feels that this is happening and therefore it should happen like this.
Sure.
Some mechanism, maybe in-house procedure, and I take the principle this, which is, even a common man, even when a complaint or an FIR is lodged,
right,
the matter goes to the magistrate whether a case is made out or not. only when the case is made out, the matter goes for a summons case or a trial case. So even if a common man is given that liberty under the CRPC, I think judges also should not be, straight away sent to the into the dock, and for this, on the slightest pretext, they should go to the SIT. But yes, if there are, we will have to believe we will have to believe some institution, some forum, whether to go into it further or nip it in the bud. After all, if you keep on doubting, even we even doubt God, whether God is there or God exists or doesn't exist. So someone will have to be believed on that forum. And why should that someone be SIT or CBI only and not the judges?
Right. You made a fair point there, Justice Mishra, but let me take it to Aman Lekhi. And Aman Lekhi, the Supreme Court says that loose talk against the Chief Justice of India is hurting the credibility of the judicial system. But, many would argue that what's hurting the credibility is the inaction on cases of judicial corruption. Do you believe that, why is it that even today, even in 2017, judicial corruption is such a taboo? It's an issue that people just don't talk enough about, let alone take action about it.
No, I completely agree. As far as judiciary is concerned, it should be above all allegations of corruption, because credibility of its justice dispensing mechanism is at stake, and any kind of slur on it is something which will harm it and undermine the confidence of people in it. The question is, how do we deal with it? Ideally, there should be an in-house mechanism, because I would not trust an outsider to deal with the judges, because I personally feel that that will in some way impact upon the independence. The point is, the in-house mechanism is non-statutory. So whatever recommendation is made or decision is taken, there is no way in which it can be enforced, or you can actually force or compel a judge to actually act on the basis of decision which is being taken. This is a matter which does require deliberation and scrutiny. I personally think we have to devise methods so that any aspersion of misconduct is dealt with immediately, and whoever is a rotten apple in the judiciary is actually cast aside to save the institution as such. There are precedents, competing precedents in other jurisdictions, whether it's UK or USA, which we can take into account. But ideally, I would not want an external agency to look into these aspects, and it is for the judiciary as such. And here the lawyers also have to intervene and join hands with the judges to actually devise a mechanism which can insulate the judiciary from such accusations and actually save the judiciary from judges who bring a bad name to it, because as far as otherwise the functioning of the judiciary is concerned on the whole, I don't think that it is lacking in any case. Yes, there are instances of abuse which become the focus of attention, rightly so, but nevertheless, hopefully and happily, they are the exception and not the norm. So any mechanism has necessarily to be an in-house mechanism. There has to be the least possible external interference in this particular mechanism, but there has to be some kind of statutory underpinning for this mechanism to in some way insulate the judge concerned from adverse criticism, which is premature and unnecessary, as is happening in this particular case. At the same time, address legitimate concerns about a judge's corruptibility so as to deal with it substantively and properly.
Okay, Kamini Jaiswal wanted to come in on that. While Aman Lekhi does make the distinction between some who are rotten apples and bring a bad name, but by and large, he does agree that, in India, the corruption in judiciary is still a very taboo subject. I mean, I don't know what the fear is. Is it fear of contempt? Is it fear of, because the judges are supposed to be sacrosanct and nothing can be said against that institution? I don't know. I can't put my finger on this. But will you agree that there is this sort of taboo to speak about judicial corruption?
No, I don't think speaking is the, speaking is the issue. It doesn't solve anything. What is required is an independent agency. We have been saying it for decades. There must be an independent body for appointment of judges. They should not be appointing themselves. There should be an independent agency for appointment of judges, and that very agency should be a permanent body which will also go into the charges and allegations that may be levelled against them, conduct a discreet inquiry, should have the power to investigate and should have the power to recommend action. So, we must have very high powered independent body to look into the appointment and removal of judges.
Sorry, Sorabji, quick closing comments from our panel. Does this raise the bigger issue on judicial appointments like Kamini Jaiswal made? Is that what needs to be fixed? And of course, is NGAC that the government has floated, is that necessarily a good thing? How can you have an independent mechanism for appointment of judiciary that is sort of devoid of any sort of political interference? What's the way forward?
One thing is clear, we don't want the executive to come in. Yes, perception is important. What Kamini said is important. But please, let's take a balanced view. We can't every time ask for a recusal of a judge because allegations are made against him. You must trust someone. If you can't trust the Chief Justice, I'm sorry. What I'm trying to tell is, I'm very much concerned about the common man's faith in the judiciary. The common man's perception the judiciary is independent, neutral, and will get justice. And that should not be in any way affected. Now, I think it's a good opportunity for the legal fraternity, the judiciary, to get together and to devise a mechanism which will satisfy the basic requirement that I don't believe that judges are taboo. It's not taboo at all. You can speak about it. In fact, if I may just divert, there was in Contempt of Court at one stage the rule that if you said anything about a judge, even if it's true, truth is no defense in contempt. When I was Attorney General, I said, no, make an exception. Satyameta Jayate makes no sense. Truth is a defense in public interest. So you can really make allegations and say, well, I'll substantiate it. I'll prove it. Formally you were prevented from doing it. But that should be done with a sense of seriousness and responsibility. It's very easy to make general propositions. It has to be worked out properly. And my only hope and request is that we in the legal profession and even the judiciary itself will work together to find a proper answer to this very vexed problem.
Indeed, that's all our hope, isn't it, Mr. Sorabji, Justice Mishra, Justice Saldana, Ms. Kamini Jaiswal, and Mr. Aman Lekhi. Thank you so much for taking time out and joining us in this intriguing debate on judging the judges and the role for more reforms in the judiciary in light of this massive controversy that's erupted over this particular cases. Thank you so much for joining us at ET Now on the India Development Debate. Judiciary for many in India is the last resort to address every crisis, and so the judiciary has to be above all suspicion. However, that said, casting aspersions and loose talk only erodes the credibility of the institution.
Trust in that institution is of course key, and that failed it will be intact if judicial reforms that many speak about take off at the same time. It's time for some soul searching and time for a healthy public discourse to also happen on judging the judges. On that note, thank you very much for being with us on this edition of the India Development Debate. Up next, it's Top 10 at 10.
Good night.